Good morning. The judgment which I am going to discuss today was only for senior lawyers and also young lawyers who want to enrich their knowledge in other field also, how to attack the authorities order who are competent to decide the issues by quasi-judicial procedure. So, if you want, you can go through the judgment in entirety to understand with so many judgments, including foreign judgments, how the quasi-judicial authorities are considered as a list. That means they are dealing with the adjudicatory position. So I will now just straight away go to AR 2024, Supreme Court 5478. For young lawyers, you can understand apart from the other so many courts, there are small tribunals, and particularly if you have any grievance, young lawyer, if you have any grievance about the services rendered at the airport, you can very well follow the judgment and apply or give complaint for improper service. Number one, this is AR 2024, Supreme Court 5478, Airport Economic Regulatory Authority of India. Airport Economic Regulatory Authority of India. So I will just read the ratios. This is say the Airport Economic Regulatory Authority of India Act, Section 31, judicial or quasi-judicial authority. Implement in appeal against this order principle regarding explained. Because if this judicial authority, the Supreme Court time and again instructed about the deprecated practice of impleading the judicial officer. But here, since this authority is the tribunal, may be adjudicated regulatory functions, the authority may be a contesting party in appeal against an order. So that is what this is say, because the authority who have got competent to dispose the quasi-judicial functions when filed an appeal, the question of law was arose. The next one, the same authority act, Economic Regulatory Authority Act, Section 31, Civil Order 1, Rule 10, appeal, necessary and proper parties in regulatory proceedings. So they have held that they are necessary parties. Then section quasi-judicial authority, scope and relevance of the concept. That was discussed how doctrine of fairness, reasonableness, all administrative action, even if there is nothing judicial, are required to comply the principle of natural justice. So all these things will have much knowledge in preparing the grounds. If you are challenging the authorities, like cancellation of patta, like the tribunal dealing with the Senior Citizen Act and so on, so on. Then they say, then again, whether the functioning of the act is adjudicatory or not, that how they have decided. The section factor is that it is not necessary that legislative action must always be subjective and an adjudicatory function objective in Sitaram Sugar case. So they have discussed that also. Then question arises, this act is empowered for tariff fixation, and I will refer that what all are the functions enumerated for this authority act. So the Supreme Court held that under section 13(1)(a) of the ERA Act, Airport Economic Regular, it is not RERA, it is ERA Act. They say Airport Economic Authority performs a regulatory function while determining tariff. That is what the ratio. Then different tariff structures may be determined for different airports, and the requirement to follow principle of natural justice would not make functions adjudicatory nature, regulatory nature or adjudicatory nature. Then question arises, the Airport Economic Regulatory Authority's orders are appealable for TDSAT. TDSAT. TDSAT means Telecommunication Authority. I will read it fully without instead of blindly reading it. TDSAT confer, though not expressly, they can file appeal against the order of this TERA. You can file appeal against the order of TERA. So this is what they say. Telecom Dispute Settlement and Appellate Tribunal. That is a tribunal, appellate tribunal provisions for these ERA orders. So that is you have to go through this. Then I will read these provisions. Section 2A of the ERA Act. What are the provisions so that you can concentrate on these issues and give complaint to authority ERA. This they have got aeronautical services, got navigation, surveillance, supportive communication for air traffic management, for the landing, housing or parking of aircraft or any other ground facility offered in connection with aircraft operation at an airport, for ground safety and services, safety services, for ground handling services relating to aircraft, passenger and cargo at an airport, for the cargo facility at an airport, for supply of fuel to aircraft, for stakeholder at an airport. Section 14 confers ERA with the power to call for information and conduct investigation regarding the activities of service provider. In airport, every airport, multi number of service providers are there. You can very well question them. Call for service provider to furnish in writing such information explanation relating to its function to access the performance of the service provider. Appoint a person to inquire affair of service provider. Direct the inspection of book of accounts, other documents of any service provider. Issue direction to monitor performance of service provider. So young lawyers can concentrate on this paragraph 6 and section 2 of the ERA Act, so that you can at least slowly start your knowledge in this particular judgment also. I hope you understand my endeavor to share the judgment, young lawyers. Best wishes.